Morning, everyone. It's a great pleasure to have you with us for another dispute resolution webinar. We've got some very interesting and relevant topics to cover today. And we've got lots to talk about. We always find ourselves, especially in rehearsals, going on and on because there's so much to say. There's so much happening with regards to COVID-19, the pandemic, the restrictions, the difficulty that businesses are facing, the pressures on contracts, on contractual obligations, and on solvency as well. So really, really tough times continue for so many people. We've got so much to say about it, but we're going to try and keep things as brief as possible so that we give you an overview of the kind of issues that we're seeing cropping up time and time again, and that people seem to need advice on very, very frequently. So here we go. It's all about COVID contracts and a little bit of focus on corporate solvency issues. When I say COVID contracts, I mean what happens to contracts in these difficult times. People are trying to get out of them. You're trying to stop people getting out of them, perhaps. So what can we find out about that? So before I move on to the main content of the webinar, if I could have the next slide, please. I thought it'd be interesting to run a couple of poll questions again, just to find out how the audience are finding the current situation with regards to contract. But here we go. Could you all answer this question, please? Have you tried to withdraw from, or are you considering withdrawing from, a contract as a consequence of COVID-19? If you answer that, we'll wait for the answers to come in, and then it'll let us know what percentage of you answer to each category. So 38% of people, that's a fairly chunky percentage, perhaps more than I'd imagined. We all know that there are people with these issues floating around, but a lot of them haven't quite got to the point of actually trying to do something about it. Thank you very much for that. We'll move on to the next question then. Flipping the coin around, has another party that you're connected to in some way tried to withdraw from a contract as a direct consequence of COVID-19? But has another party that you're connected to tried to withdraw from a contract with you as a direct consequence of COVID-19? Some results still coming in, thank you for that. We'll just keep this going as long as the results come in. And here we go, a much higher percentage. So 75% of people have been on the other side of that. We've seen a lot of that. We've seen it in all walks of business. People trying not only to get out of contracts entirely, but to get out of their contractual obligations as well. So there you go. Let's move on now to the main content of the session. So it's split into 5 sections. We'll try and move through them as quickly as possible whilst giving you the main information you need. We'll start off with a section from Johnny. So part 1 is Johnny looking at the government guidance on dealing with contractual obligations. I'll then move on to talk about our recommendations for safely navigating contract disputes. Then we'll look at withdrawing from a contract, so that's termination, things like force majeure and other considerations. A little bit of a closer look at termination as a kind of doctrine in law. And I'll flesh that out in much greater detail as we go through. I'll then finish off my contribution with some case studies, so attempts to withdraw from a contract. A couple of case studies, including Cineworld and Cineplex. And then back to Johnny for a useful look at the liability of directors under the new corporate insolvency and governance bill, and with the message basically, beware Directors Disqualification Act and personal liability of directors. So it splits into 5 sections. Without too much ado, I'm just going to remind you that number 1, please submit your questions using the Q&A function, and we'll answer them towards the end of the webinar. And lastly, use the chat function if you've got any admin problems or if you've got any suggestions or feedback regarding the webinar today. We love to hear your feedback, whether it's during, whether it's after. Please do let us know what you think of this webinar, how useful it was, and whether there's anything that you prefer to have covered, for us to have covered. Or whether there was anything that was just spot on. So that helps us to kind of tailor on our future events. Oh, Johnny, I'll hand straight over to you. Thank you very much.
Thanks, Phil. Right, that's me, just down the bottom there. What I'm going to do now is just move swiftly on to the next slide. And it's really interesting, the poll results there, that there has been an attempt by counterparties to get out of their contractual obligations by reference to the COVID-19 emergency. And we're going to come on to that, some useful provisions in the second part of my talk. But right now we're going to deal with what I'm calling the soft part of the legislature's approach to the COVID-19 emergency, and that is the guidance issued by the Cabinet Office and the Infrastructure and Project Authority. And that was first issued, as we can see there, on the 7th of May 2020. And what's interesting is it was issued by the Cabinet Office, which, as you probably know, reports directly to the Prime Minister. So it was obviously something that Mr. Johnson looked after and had some dealing with in terms of drafting personally. Certainly his quite a small department within the government set up, but nonetheless, obviously the absolutely crucial one, reporting as it does to the Prime Minister. Gives you some idea of the emphasis that this received from the executive branch of government in the first instance. Now, I'm not going to deal so much with the first part of the guidance because it's largely been overtaken and updated by 3 weeks ago, the second guidance updated 1st of July 2020. And let me just read that for you briefly. In summary, the government is strongly encouraging all individuals, businesses, including funders, funders are lenders basically, and public authorities to act responsibly and fairly in the national interest in performing and enforcing their contracts to support the response to COVID-19 and to protect jobs and the economy. So effectively, what the government is saying is, look, be reasonable, be nice to each other, okay? And that really is what it boils down to. Now, I think there's a sting in the tail, and I'm going to come on to that later. Now, it's worth pointing out that the guidance is not statutory. It's not made under an Act of Parliament. It has not got the force of an Act of Parliament. It's not a statutory instrument or a regulation or a directive or anything of that nature. And as such, it does not override contractual provisions. Okay, and we can see there, that's another quote from the guidance. It's not intended, the guidance that is, to override specific contracts whose primary purpose is to make express and clear provision for and allocate risks in respect of the effects of global or national public health emergencies, pandemics, especially contracts and insurance, though the government would encourage fair and responsible dealing. And Rob's going to come on to the contractual provisions, which you may have in your contracts. Read them carefully. He's going to come on to that in a second. And what they're saying there is, of course, that is move on to the next slide. Thank you, is in effect, if the contracting parties have already allocated risk and negotiated risk within the contract, we, as the courts or as the government, are not going to interfere in that. And the guidance, usefully, as we come on to this slide now, slide 7, deals with some incidents, some aspects, some instances of the of fair and responsible behaviour. So oftentimes, let's say that a delivery driver has gone down, has become unwell. Well, quite clearly, they're going to want to know, both parties are going to want to know of that, and they're going to want to come to some form of arrangement regarding late delivery. Payment terms also. We could be looking at late payment where companies are in cash flow difficulties. We're going to come on to the hard part of the government's response to the COVID emergency insofar as companies are concerned, corporate governance and insolvency, in the second part of my talk. But the government, I think, and indeed I think the courts, will expect parties to come to some form of agreement and be reasonable in respect of late payment, reduced payment, increased costs of delivery. Sometimes, of course, costs of delivery may go up, and so that you on the receiving end of goods and services may be asked to cough up, if I can put it that way, more. Okay, substitute goods may need to be delivered. We can see there the third bullet point, and that appears in the guidance also. In terms of remedies, I think the courts will also, and certainly the guidance will expect the parties to look at reduced levels of damages, returns of deposit. And I think here is the sting in the tail. The courts have, under the civil procedure rules, Rule 44, almost unlimited discretion as to how they award costs in a case. Now, normally costs follow the cause, is what we say, costs follow the event. You win your case, you get your costs from the other side, okay? Here, however, if you've behaved unreasonably, I think the courts will look at the guidance and will say, no, actually, you haven't behaved reasonably here. You've adopted a court approach when a more reasonable negotiated response would have been appropriate. And we, the courts, yes, we're going to award you the sum of £15,000 that you've claimed, but we're now going to ask you to pay £10,000 of costs to your opponent, please. So it's quite a powerful remedy that the costs have. Amber, let's slide on to the next slide. The second part of the guidance in respect of responsible and fair behaviour will look at the parties actually to renegotiate whole contracts. Not just the practical mechanics, the day-to-day part of how the contract works, which is how we were looking at the first part of the incidence of responsible and fair behaviour, but actually throughout. So they may negotiate changes in pricing throughout the validity of the contract, changes in the scope of works, timings, and goods, again, throughout the scope of the entire contract. Now, be advised, there is a second slight sting in this tale. The guidance only applies where the contract is materially affected by COVID-19. So the guidance will not apply where there has been a contractual failure, which has got nothing to do with COVID-19. Okay. Now, I know that there are people sitting, listening, who are in construction, building, or what have you, and so a note there that the Construction Leadership Council is expected to offer further guidance as imminent. Okay, move on to the next slide, please. In summary, then, very quickly, this first part of the discussion, we're looking at contracts affected by COVID-19 only, and we're looking at contracts which don't, as Rob was about to take us through, provide for allocating risks when it all goes wrong because of this, the type of thing that we're going through at the moment. And so where risk is allocated within the contract, the courts will expect you to abide by that. Rob's going to take us through that. Guidance is not statutory, but I think the courts will use the guidance to consider costs where that's appropriate, where one party has behaved unreasonably, and the enormous elephant in the room, conceivably the most important piece of legislation since 1986, Insolvency Act. It's the Corporate Insolvency and Governance Act, and we're going to come on to that right after Rob has given us the first part of his speech. Over to you, Rob.
Thank you, Johnny, much appreciated. Yeah, very succinctly put, extraordinary times, brand new legislation that we've all got to get to speed with very quickly. So let's move forward with our recommendations for navigating contract disputes. So let's try and maintain some focus. So before you do anything in a contract dispute, you really need to understand what your contract provides for, and that's really simple. So it's as simple as knowing what your contract says, what the terms of your contract are. It might not be in a single document. It might be in you've got a standard set of standard terms that are referred to in the main contract. There might be a couple of documents, or there might be more. So know what your contract is and know what it says. I know that's really sounds really obvious, but we all need to be reminded time and time again to check what the provisions of a contract are very closely before you even think about raising a dispute with your other party to the contract. I was going to say opponent, but let's not make them opponent just yet, because we might realise that the contractual terms are so stringent that we don't want to make it an opponent. So that follows on to the next bullet point here. Don't take hasty action. Okay, so carefully consider your options before you take any steps which are basically irreversible. And what might that be? So you could terminate a contract not being aware of the horrendous consequences of termination. I'll give you a quick example. I was acting for a client once who leased a very, very expensive telephony system. They decided that the service they were getting was so poor that they were going to terminate the contract. They gave notice of termination and packed up all the telephony equipment and said to the other side, come and get it, it's all yours. Okay, well that was job done, that's the contract terminated. They didn't check the consequences of termination, and what the consequences were that they basically had to carry on paying the full contractual payments for the next 5 years. Okay, so they got no discount whatsoever based on the fact that there was an early termination, and they didn't even have the benefit of the actual poorly performing telephony equipment, but they had to pay for it anyway. So watch out for hasty action. Directly leading on to that next point, then, get advice before you act. And if that advice tells you, crikey, that this might be a sticky situation, such as the example I've just given you, then think about working collaboratively with your commercial partners before you start loading up the machine guns and aiming missiles at the other side. Take heed of the government advice that, or the guidance that Johnny's just run us through, and be prepared to quote it as well, because that just gives you a lot more credibility in arguments regarding the consequences of COVID-19 and how that's affected you in your contract. Moving on then to the next slide. So terminating the contract. This is the section 2. Can we have the next slide, please, Amber? So what are the key factors? Well, as I've already said, wording of the contract, that's fundamental. There's nothing more important than what the contract itself actually says. And we'll get to understand that a little bit more as we go into more detail. But I think you all know and appreciate that you know, contracts are agreements between two parties, and especially in commercial contracts, you can pretty much agree what you like. So no two contracts are likely to be the same, except if they're on standard terms. So let's make sure we know what the wording of the contract is. Other key factors in terms of termination, the actual factual events giving rise to an alleged right to terminate. What might that be? That might be a breach of contract, such as failure to pay, for example. Questioning ourselves whether there's been a breach at all, and whether we're in breach before we try and allege breach on the other side. Because quite frequently what will happen is, we'll see from one of the case studies, we'll allege breach and they'll straight away allege breach straight back. And then this important question, the last bullet point you'll see in front of you, has the breach that we're going to rely on, or seek to rely on, actually been waived? And that means, for example, have we delayed in relying on that breach for far too long? So for example, with telephony, the telephony example I gave you, service has been terrible. We've just put up with it. We've moaned a couple of times on the phone to our sales rep, but we've never recorded anything in writing. We've never given the other side formal notice as we're required to under the contract. And so if we wait for 6 months without taking any formal action, you know, we're more than likely to have waived our right to breach, which means we can't rely on the other side's breach as a ground for termination. So watch out for waiver. Next slide, please. Right, now this is a little bit of a mini workshop on termination. So really relevant, as I said, because contractual obligations under COVID-19 restrictions are so strained at the moment that many parties are looking to get out of their contractual obligations. For you guys, it looks like for the vast majority of you, you're seeing it from the side of the innocent party, who is having someone come to them and say, look, we need to get out of this, full stop, or they're just failing to comply with their obligations. So a difficult situation. So I'm going to run through a series of points, or a series of factors that people rely on to terminate contracts. Okay? It's often assumed that if someone does something wrong under a contract, or something goes badly wrong, there's a material change in the circumstances, you can get out of the contract. Well, the simple lesson is no, you cannot. Okay? The simple lesson number two is be extremely careful, because in most situations you can't terminate your contract unless there's an express provision for you to be able to do so. So you'll see what I mean as I work through each of these scenarios. So the first bullet point is a classic. This is one that many of you will have experienced, where one party to a contract realizes that it's really not, to say it's no longer convenient for them to carry on with a contractual obligation is a massive understatement in the circumstances we find ourselves in. I suppose better words are those that follow. The contract is no longer profitable. Okay, they find themselves in a situation where they have no revenue, so they can't pay for the services that they've contracted to have provided. So, it's not profitable. They can't afford to proceed with this contract. Can they get out of the contract on that basis? Well, if the contract has nothing express to let them get out of the contract on those grounds, then absolutely no, fundamentally no. Okay. The strange thing within our law is that commercial parties are fundamentally entitled to enter into bad bargains. Okay, even if they thought it was a good bargain at the beginning, and it turns into a bad bargain. And what I mean by that bad bargain is that, for example, the example I gave a couple of seconds ago about it no longer being feasible or profitable for you to carry on with a contract. And note the word feasible, very different to the word frustrations we'll come on to. Breaches then, what about breaches? So I'll cover off the next couple of bullet points in a while. We've got a minor breach, a material breach, a substantial breach, and we've got repeated breaches. Now you would have thought that perhaps with repeated breaches, maybe even material or substantial breaches, that those things automatically provide a right to terminate, okay? But they do not. There is no automatic right for termination to the innocent party unless you have an express term in your contract that allows you to rely on those breaches for termination. So watch out. The situation with a repudiatory breach, the next bullet point down, is very, very different. And by repudiatory breach, we mean a breach that is so serious it goes to the very heart of the contract. Okay, let me give you a quick example. Let's say it's stipulated within the contract that time is of the essence. Okay, give you an example: sale of a commercial property. Time is of the essence with regards to completion, and if there are no other standard terms relied upon, then we know that if the completion doesn't go ahead by the time it's required to, that deadline, it doesn't matter how much it's got over that deadline, it's a repudiatory breach, and the innocent party is entitled to rely on that repudiatory breach, which means they can say the contract is at an end. Okay, you have breached this contract to a repudiatory extent. It's a repudiatory breach, so I'm entitled to accept that repudiation, and the contract must come to an end. That's the big difference with a repudiatory breach, right? But beware, because often people think that a breach is so serious that it is a repudiation, when in fact it's just a material breach, and you're not entitled to terminate. So the important thing is that if you're ever going to rely on repudiatory breach, get advice. Don't just automatically think that it's your right to terminate. Moving on to the next one then, insolvency. So often people think if another party to a contract becomes insolvent, then they're entitled, the innocent party is entitled to walk away. As with the point above, that's not the case. Your contractual obligations will carry on, even if the party on the other side becomes insolvent. Okay? The administrator or the liquidator will have powers to carry on running a company to a certain extent, and certainly to carry on to realise assets. So that means you are not off the hook just because the other side to a contract becomes insolvent. Of course, many contracts do provide express terms for insolvency, and they will say, for example, watch out, they will say if a party sustains an insolvency event, then you are entitled to rely on that to terminate the contract. But that's an express term, okay? It's not automatically a right for you. to rely on that insolvency event to terminate the contract. Very similar when it comes to death or incapacity of an individual. Your contractual obligations don't go away, because the estate of that person can do the same as in a corporate scenario, corporate insolvency scenario, and say you need to carry on fulfilling your obligations under the contract. For the next slide, please. So dissolution, that's slightly different. We're talking about a company being dissolved. I'm not talking about insolvency here. So I'm talking about a company disappearing. Let's say, for example, because it's failed to file its accounts, it's failed to file other documents at Company's House, so it's been automatically struck off the register. When a company is dissolved, it is no longer capable of fulfilling any contractual obligation whatsoever. So if you're on the other side to that, as the innocent party, you are completely off the hook with regards to contractual obligations, whether it be to pay or to perform a service, all right? Watch out though, because with dissolution is that strange situation where the company can actually be brought back to life if someone applies to have it reinstated to the register. But it doesn't happen that often. Just remember, dissolution means company can't do anything. You can't even give the company notice that you're terminating the contract. Everything's at an end. Next two bullet points. So change of control with regards to one of the parties. So I'm talking here about a company being a party to a contract that changes its shareholders, okay? Or maybe one of its shareholders acquires a controlling share in the company. Does that give you a right to terminate just because of those circumstances? Well, as you all know, many contracts do provide for those kind of scenarios, and they will give you a right to terminate. But if there is no express term, then of course that does not give you a right to terminate your contract. Okay. So then, perhaps the most pertinent bullet point of those that we've looked at already, COVID-19 doesn't give you any automatic right to terminate your contract just because you're suffering. And we saw that with the first bullet point, whether it be breach, whether that be it turning into a bad bargain, it no longer being convenient for you to run a contract, to fulfill your contractual obligations. Well, COVID-19 creates the situation, those kind of situations. Many people are trying to rely on force majeure. Now, I've been over that in a lot more detail in my first webinar. But think about force majeure very simply. If it's not in the contract as a contractual term, forget about it, okay? If you don't have an express term, forget about it. If you do have an express term, you're not completely home and dry, because it needs to be wide enough to encompass the situation that you're relying on. So if it's COVID-19, does it include a pandemic? Does it include any unforeseeable event whatsoever? Is it broad enough to cover you in this situation? It might not be. But just remember, again, before relying on it, take advice, or make sure you fully understand the term that you're relying on, that force majeure clause, before you go and take irreversible steps to terminate the contract. Frustration is very, very different. So is there something that has happened to frustrate your contract? And again, not again, but this is the opposite to force majeure, because it doesn't have to be within the contract. You can rely upon it. All right, so it's something that is so serious. It's something that creates radically different circumstances to the ones that were prevailing previously. That means that it would not be right for the parties to have to comply with their obligations under the contract. Let me give you an example. Let's say a party agrees to lease a commercial premises to another. Shortly before the lease is due to commence, the building burns down. In those circumstances, you can't expect the landlord to fulfill his obligations to provide that premises, that specific premises, to the potential landlord. Okay? So that's frustration. You can see that that's quite a radical change in circumstances. Again, this is not inconvenience. This is not the situation changing so that I can no longer afford to fulfill my obligations. It's more, extremely serious change in circumstances. And the courts do not like frustration. So it's very rare for parties to successfully rely upon that. So I think what we're learning from all of these points that I've covered is that if you do not have an express term in your contract with regards to termination, then you need to tread extremely carefully before seeking to try and terminate your contract. I hope that's clear. Please let me have any questions on the Q&A function. If it's not, or drop me an email shortly afterwards or now. But there you go, that's the advice. Tread carefully, look at the terms of the contract. Remember, if there's nothing expressed on termination, then it's likely that you're not going to get home and dry with regards to termination, except in some of these exceptional circumstances, such as repudiation, such as force majeure, such as frustration. So then, the last of my sections, a couple of case studies. So what I'd like to do is try and explain the points that I've been just going on about a few minutes ago in the context of some real life examples. So let's start with Cineplex and Cineworld. So many of you may have heard about this in the news. So this is a really classic case. If you read this story, you will automatically think, crikey, Cineworld's just trying to get out of this deal. So in December 2019, Cineworld announced that it had agreed to take over Cineplex for a $2.1 billion takeover. Okay? So when it says it's agreed, what that means is it's entered into a long and complex arrangement agreement for the purchase of Cineplex. All right. Fast forward a couple of months, COVID-19 strikes, restrictions bear down on most developing countries, and what do we see? Cineworld suddenly says, we're not going ahead. We are not purchasing Cineplex for $2.1 billion. No way in the world. And what they're saying is, thank goodness, we've got some terms within the contract that we can rely on. So there's some express terms. There is a material adverse change clause within the agreement that says if there anything that changes materially to an adverse extent, then the parties are entitled to withdraw from the contract. I'm also saying, note this one, there are certain unremedied breaches of contract. Most likely these are going to be minor breaches, but let's remember what we said earlier. If there are express terms dealing with that, then what typically happens is that in the contract it will say, if either party breaches the contract and it's given notice of those breaches and fails to remedy that breach within, say, 14 days, 28 days, whatever the contract says, then the other party is entitled to terminate. Okay, and that's what Cineworld is saying it wants to do. It's not just saying, well, the value of Cineplex has just decreased radically. I've just struck a bad bargain. I thought I was striking a bad bargain. It's probably thinking that, but what it's doing legally is relying on some express terms that are hopefully going to get it off the hook, it thinks. Cineplex, on the other hand, immediately has said it's going to counterclaim. So, forgive me, Cineplex is the one that is going to claim against Cineworld. He's going to claim $1.1 billion in damages, and it alleges that Cineworld has that famous concept of buyer's remorse in mind. So there you go, Cineplex making a huge claim against Cineworld, whereas Cineworld is going to counterclaim for its own damages as a result of the breaches that it's alleged. Okay, so I hope you get that. That's going to be a very complex and long-lasting dispute and expensive to run. But you can see there what the advantages of having a detailed, well thought out express agreement that creates opportunities for parties to terminate the agreement in sensible, reasonable circumstances. Okay, that's that one. Let's contrast that with the next example. And we're talking about a random holiday company. And this case study is based on advice that we've been asked to provide for a number of clients. It's been based on anecdotal evidence of companies struggling with contractual obligations, whether that be in the news or whether that be speaking with clients and contacts about how they're faring in the COVID-19 pandemic situation. So imagine, it won't be very hard for you to imagine, but we've got Company Act, which is a holiday company. Some time ago, had entered into a 3-year IT management services agreement. Within that agreement, there are express termination provisions, okay? But it only allows for termination in the event of a breach that is not remedied within 14 days, or insolvency of the other party, right? There is no force majeure clause. So remember what we said about that. If there's no contractual provision, forget about force majeure. It's off the table, okay? Company X has suffered so badly because of the COVID-19 restrictions that it's got no revenue. And it wants to get out of this agreement. It's a bad bargain now because it simply cannot afford to pay the thousands of pounds it agreed to pay. And frankly, it doesn't need those services when it's not doing any business whatsoever. What's it going to do? We'll move on to the next slide, please. Well, you remember that hopefully those words are ringing in your heads now. Companies, this company must look closely at the wording of the contract. It's got to consider, have there been any unremedied breaches of the agreement? You know, has the IT company suffered any kind of insolvency event that I relied on? And what it's trying to do is there a sensible grounds? Is there an express ground upon which I can terminate this agreement? Because I'm fairly sure, the company says to itself, having got advice, that I can't rely on any of the common law rights to terminate this agreement. I don't think there's been a repudiatory breach of the agreement. I don't think there's been anything that's so serious. The IT company has been doing its job. Okay, it might have committed some minor breaches, but then we're looking at the express terms, and if we can find anything that we can rely on as an express termination provision, then that's what the company's going to have to do. All right. I think with regards to unremedied breaches, as I said before, the main problem with those is that the innocent party often doesn't raise them and just runs with them and just doesn't say anything, except maybe inform me on the phone. And what they don't do is give the other party notice of that breach and say, you need to remedy this within the specified time frame. With regards to insolvency, what we find is that most of the time in this kind of situation, it's no, it's a no-hoper. But sometimes we're surprised that, for example, a company might have entered into a CVA. If it's administration or liquidation, we're probably going to know about it. But we have been surprised in the past. Companies have entered into a CVA, and then bang, we have a right to terminate the contract because of that. All right. So there you go. That's what it's got to do. If there are no grounds for relying on those two termination mechanisms, and it's got to consider frustration. Well, as we said a minute ago, that's unlikely to work. This is not a situation that's so radically different from what had been envisaged. It's just simply less convenient for the holiday company to meet its obligations. And then if that fails, then we're looking into the good old cooperation, which lots of people overlook. So before going legal, think about how you can cooperate and collaborate with the IT company to try and find some kind of agreeable solution. And that takes us back to the first section of this webinar, Johnny's very helpful explanation of the government guidance on contractual obligations. Think about that, have a look at that, speak to us about that, and see if there's anything you can throw back at the other side and say, look, this has only come about because of COVID-19. We need your help. The government thinks you should help us in this situation. So let's come to an agreement. So there you go. Those are the two case studies that flesh out that long list of bullet points that I started with in section 2 of the webinar. Any questions, please do write them down. But that's all I've got to say. And I'll now hand over to Johnny, who's going to finish off with section 5. And then if we've got any questions from you, we'll answer those. Many thanks.
Thanks, Rob. Right, well, this is the Corporate Insolvency and Government Bill Act now, of course, having received royal assent. And it is probably the most significant piece of corporate governance stroke insolvency legislation since the great 1986 Insolvency Act. So what is that, 34 years? God, I trust my maths. Right, it received royal assent less than a month ago, and it is by far the most far-reaching reform in recent years. So in the first part of our discussion, the softer part of our discussion, we looked at how the government's touchy-feely approach to how parties should be nice to each other and get matey and sort it out. This is something altogether different. This is a game changer, and we're going to move on to this piece of legislation. If we could move on to the next slide. And what we're going to have in our minds, if Amber, we could just slide on to, there we go, the next slide. What we're going to have in our minds, because I know most of the people watching this are going to be corporate directors. You and I are going to place ourselves in a position of a corporate director on both sides of the equation, the supplying side and the paying side. So winding up petitions are out. So if we are in charge of a corporation company and we are on the wrong end of a creditor, what that creditor cannot do, at least until the end of September of this year, is issue a winding up petition. Now that's like the nuclear option. So in effect, that has disarmed the creditor to a large, to a really a huge extent. So it's worth pointing that out. Indeed, that was used in a case to a company, and that was decided on June the 2nd this year, when it still was a bill, and the bill was used to defeat the petition, and the court, Mr. Justice Mumley, upheld it in the High Court and said, yes, this act is going to provide a defence. I'm going to throw out the petition. And so the creditor was left holding a bill of costs for the proceedings. Now, conversely, if we are the creditor, our nuclear option is gone, at least until the 30th of September 2020. But if we as the creditor can show, and here we put ourselves as directors of a creditor company, owed a lot of money by another company, if we can show that the insolvency had nothing to do with the COVID emergency, the court will uphold our petition. Now, I think that's actually going to lead to a whole load of satellite litigation, with parties not arguing about the validity of the debt, but arguing about whether not only the debt is valid, but also that the debt is not related to, or is related to, whichever side of the fence you're arguing from, creditor or debtor, the COVID emergency. And so complicated is the legislation that they had to put a whole schedule onto the act during the committee stages. So let's say that we are the directors of a company and we're having difficulties. There's nothing in the bank and we're in trouble. Okay, what this act does is to introduce a whole new concept into English law, very much akin, and that's why I put it there in the notes, third bullet point, to the Chapter 11 US bankruptcy jurisdiction, where we as a company director can go along to the court with the paperwork all in place and say, we need 20 days breathing space, please, to seek either finance from the private sector, which you have to do first, obviously, before qualifying for CBILS or anything like that, government assistance. You have to go to the private sector first, and then if you're refused there, you then go to the government lending facilities in place to deal with the COVID emergency, courtesy of the Chancellor. Now, what are the instances of a moratorium? In effect, what it does is this. Because we're in the director here, we're with this company that's in trouble, the court will say, right, your debts up to the date the moratorium came into force are now frozen. But the debts that fall due during the moratorium period are payable. that's quite interesting. But the rationale, I know we could go behind the rationale of the Chancellor and probably lose the will to live, frankly. But those are the rules. Them is the rules. Now you need to have a monitor, what they call a monitor, in place, who's a suitably qualified accountant who can certify that the company will get through the period and then trade afterwards as going concern. So your initial period is 20 days. You've got 20 days in the bank. We don't need anybody's consent. All we need is the court to come along and say, yep, rubber stamp, that's fine. Got your paperwork in order, got your monitor in place, wonderful. We can then apply to the court for a further 20 business days, but this time we must then confirm that the debts pre-moratorium will be met. And then we can go all the way to 1 year with the consent of our creditors. And that gives companies a great big breathing space. And creditors, when faced with either a haircut or a total loss, will normally go for the haircut. Let's move on to the next slide. Just point that up on my computer. There we go. Right. So if we look at winding up petitions, we can see that during this period, the relevant period up to the 30th of September 2020, winding up petitions are out, all right? And then during the moratorium period, we're paying current debts, but not pre-existing debts. A monitor is appointed, and the provisions there are under Chapter 4 of the Corporate Insolvency Governance Act. So really, it does provide us with, as company directors, faced with a company that's struggling, frankly, and struggling due to the COVID emergency, we can go along to the court for relief under this whole new regime. Let's move on now quickly to the next slide. Now, what are our duties during this problematic period that we're going through? Well, in short, the director's duties, okay, remain the same. And we'll come on to that in just a second. But the Insolvency Act comes along, okay? And normally, in normal times, if the liquidator who's liquidating the company says, grabs him by the collar and says, Johnny, you have behaved so badly as a company director that you were incurring debts when you knew, or you should have known, as a reasonable director, reasonably competent director, that you had no chance of paying off those debts, then I have to reach into my pocket from my own funds to put those into the company funds in the liquidation for distribution to creditors. Those are the provisions of Section 214 to Section 246ZB of the current Act. What the new Act does, what the new Corporate Insolvency and Governance Act does, is to disapply that. In other words, it is not open to a liquidator to seek to grab funds from a company director where the company has gone under, provided it's gone under as a result of the COVID emergency. By gone under, I mean it's entered into insolvent liquidation, the insolvent liquidation process. Okay, that's what I mean by gone under. So what the new Act does there, we can see there, the second bullet, is suspend those provisions of the Insolvency Act, okay, during this relevant period. And it's the same relevant period as the suspension of the winding up petition, okay, from the 1st of March to the 30th of September 2020. So if conditions have worsened, let's say you're running a cinema, say Rob's example, and so you're not allowed to trade as from the 23rd of March when the lockdown began, well then clearly your conditions of trade are going to worsen, but that's nothing to do with you, okay? If, however, before then you were trading at a loss, you continued to trade at a loss, and the company went down, insolvent liquidation, then I'm afraid the liquidator may be able to argue that no, with the best of them in the world, trading conditions did not worsen due to COVID. That may have been the final nail in the coffin, but was in fact due to your own incompetence. And if you're in that neck of the woods, then you are still potentially grabbable under to make contributions under that Act. All that being said, our duties as directors remain in place, and we all know them. Exercise competent judgment, exercise independent judgment, exercise that judgment in the best interests of the company and stakeholders. We all know them, we're all au fait with them. I don't think we need to go through with them there. There are 7, 8 in all, and they are at the Companies Act 2006, sections 171 to 178, if you want to look them up. So we as directors are still required to act responsibly. The Corporate Insolvency Governance Act does not give us carte blanche to say, well, okay, great, we can pretty much do what we want to do. We are still required to act responsibly. And on a practical note, let's look at what Rob was saying earlier. He's quite right in respect of what we call ipso facto clauses. Now, an ipso facto clause, is very quickly, it's where me, as somebody who is supplying you its goods, and if your company enters into an insolvency process, by virtue of that fact, ipso facto, of that situation that you're going into some form of insolvency process or administration process under the Insolvency Act, I am allowed to alter the terms of trade, stop supplying you, etc., etc., etc. Now, that is absolutely correct. I am now, by virtue of this act, no longer allowed to rely on that, and I have to continue to supply you on the same terms and conditions. I have to say on a practical note that if you guys as directors came to me and said, Johnny, we have a problem, we think this company is going under. In other words, the company that we're supplying goods and services to, we think is going under. We can't afford to extend credit, frankly, if it's going to go under and we're going to be left effectively having supplied goods and services and not being paid for them. Then come and see me and we will find a way through. Because if anybody thinks I'm going to advise a client to engage in what in my view is against their director's duties by continuing to supply goods and services to a company they know is not going to be able to pay them, well then I think we need a reset on that one, and a pretty robust and practical approach can be found, I suspect, with little imagination around those provisions. But beware, don't just do it. Do come and see us or anybody or a lawyer or something before you head down that route, all right? One thing that the government and the CI, the Corporate Insolvency Governance Act, has not affected though, is Section 15A of the Company Directors Disqualification Act. And you'll be relieved to hear this is the last part of my note before I sum up. What that does is this: if we as directors have really behaved very badly indeed, not only wrongfully traded, but gone beyond that, so that we are not fit to be directors and we are disqualified under the Company Directors Disqualification Act, and I used to prosecute the DTI back in the day when it was called the DTI, Department of Trade and Industry. Section 15A has much the same effect as sections 214 to 247ZB. In other words, it allows the DTI or the liquidator in those instances to come along and grab funds from a delinquent director to put into the liquidation to disperse to creditors. That has not been affected by this act. It remains in force. So do beware of your duties as a director. And finally, the last slide. You'll be relieved to hear somebody gasping for a gin and tonic or something stronger. We can see, let's just have a quick wind up of this act, which is brought in to protect companies and directors, and I think it does so, offering checks and balances. We've seen the moratorium, we've seen the suspension of winding up petitions, we've seen the suspension of the Insolvency Act, the contribution that a director can be asked to make for wrongful trading. We have seen also how the government sought to balance this by keeping the basic director's duties intact. It's not interfered in that in any way. And it has also kept, for the really bad director, the provisions of the Company Directors Disqualification Act, CPDA, Section 15A, which allows you, if you have been disqualified, I'm afraid, to provide funds in the liquidation for distribution to creditors. Right, that's it. We're done.
Thank you very much, Johnny. That's absolutely fantastic. there you go, everyone. So we've got 5 minutes left. I don't have any, I can't see any questions. Let's have a look, see if we've got any questions there. So I've got a couple of minutes. Johnny, I'm quite interested in this Chapter 11-esque new process. Just a couple of small questions on that. Number one, is 20 days meaningful? Is it meaningful enough to be a useful provision?
Well, in my view, most companies will have seen, most sensible directors will have seen the problem coming, and will already be in negotiation with their finance providers in the first instance, banks and first-tier lenders. And banks have been encouraged by the government to produce funding. Now, whether and to what extent that funding has been provided, I don't know. But I strongly suspect that 20 days will give at least an initial breathing space to companies, who can then, after all, come back and request a further 20 days. It's 20 working days, so if I wasn't clear on that. So the real answer to your question is the Act has been in force for less than 3 weeks, Robert, and we just don't know, is the answer.
Yeah.
Like, the legal profession, the accountancy profession, like every other company and service and provider in the United Kingdom, we're all feeling our way, and we're going to continue to feel our way and do the best we can, I think, for as long as this situation provides. But in my view, provided one behaves with reasonable diligence and common sense, and consults people before taking, as you put, any pulling any legal triggers that are actually irreversible in terms of costs and consequences. I think that the courts will be fairly forgiving. The golden rule, I think, when one's looking really at any form of director's duty or anything like that, is the do not take the mick rule. All right, provided one acts with reasonable diligence and care, the courts are not going to punish you for getting it honestly and diligently wrong. Where they are going to get the hump with you is where you've been reckless or closed your eyes to dangers, or behaved in a way which is morally reprehensible.
Yeah, I couldn't agree more. I mean, taking the mick is so frequently in our world, where we're dealing with disputes a lot, it comes back to haunt you so frequently, and sometimes spectacularly, ruinously. If you've taken a rash action, I can think of a shareholders dispute that I had. It went on for the best part of 3 years, and very, very close to trial, we discovered some material that blew our entire case out of the water, because our client had behaved so badly that it amounted to a repudiatory breach. We didn't know about it. We basically found it buried in a transcript of some proceedings in the US. So it's just a very clear warning. And I think the last thing I'd say, and thank you, Johnny, for those helpful comments. The last thing I would say is the way forward is always to be in a contractual relationship that's really clear, where the terms are unequivocal. I spoke to someone a couple of days ago who is trying to get out of a contract with someone that they sponsored. So it's a large multinational. They've entered into a very high value sponsorship agreement, and they're trying to get out of this contract. And their concern wasn't that they didn't have a contractual basis to rely upon. It was more that they were trying to do it in a sympathetic and responsible, corporate social responsible way. And that's how it should be. Your contract should be so clear that in that case, they had 2 or 3 obvious ways to terminate the contract. So they had their pick, because things hadn't gone to plan with COVID-19. The events that were planned to affect the sponsorship couldn't go ahead. So the company could rely on their failure, everyone's failure to deliver on those to terminate. And they didn't have to worry about the legals, because the contract was so clear. There were so many grounds for termination, fair grounds, nothing unreasonable, that all they had to worry about was keeping a good relationship with that company that they had sponsored. So if we can all end up in that position, life would be much better. Johnny, thank you very much for your time. I must say thank you to Amber James and Anne Hardy in our marketing and business development team for helping to coordinate and launch this event. So thank you to them. Thank you to each of you. Very much appreciated that you taking an hour out of your morning to listen to us. As I said, feedback is very welcome. Some of you were kind enough to email us last time and let us know how we can do things better, what you really appreciated. So please, please, please do that. It's really nice to have a broad range of disciplines in our audience. We can see we've got professionals, we can see we've got in-house counsel, we can see we've got directors. Thank you to all of you. Hope it's been relevant to all of you. But do stay in touch, drop us a line. It'd be great to hear from you. From me, from Johnny, thank you very much. From everyone at DMH Dillard, all the very best. See you next time.